Hello and welcome to Discretion Discussion, a general election debate between Republican Kevin Calvey, I should start over, shouldn't I, and Democrat Vicki Behenna, the two candidates for an open Oklahoma County District Attorney seat. My name is Trace Savage. I'm the editor-in-chief of NonDoc.com. We're an online journalism publication based here in Oklahoma, and I'm joined on the stage tonight by Storm Jones of News 9.
And as we mentioned, News 9 is streaming tonight's debate on our Facebook pages, the News 9 app, news9.com, the Facebook pages of NonDoc and other media partners such as The Frontier as well, which The Frontier will lead a fact check of tonight's debate. The Oklahoma newspaper is also a partner tonight, and Janae Williams will join us on stage a little later.
Awesome, Storm. This is our 9th time moderating a public debate this year in 2022. I really appreciate you and News 9 for standing up and supporting public candidate debates in Oklahoma. I think it's important for people to stand here in front of live humans that they seek to represent and answer just a couple fair but firm questions. If not for the sponsors of NonDoc's 2022 General Debate Series, we would not be able to make this happen and rent a wonderful facility like the auditorium at the Douglas here. I want to thank the State Chamber of Oklahoma, AARP Oklahoma, the Oklahoma Public School Resource Center, McSpadden, Milner, and Robinson, and the Oklahoma Association of Realtors and Overman Legal Group. Give them a round of applause for supporting public debates. We need like 1 million more of those sponsors too. Storm.
Since we are in public tonight and all decent people, please go ahead and silence your cell phones. And while you have your phones out, you can share that News 9 Facebook stream or the Twitter stream so your neighbors can be as informed as you all are tonight.
Now, I need to say this also, and I really need folks to hold their applause and not make any outbursts or shouts or any defamatory comments. Did I say defamatory? I don't know that that's a word, but you know what I mean. We've had situations in the past where we feel like if it happens again, we will clear the room, ask everybody to leave, and keep the debate going for the people who are watching. There's thousands of people watching, so don't shout, don't scream. We don't need that. We are a civic society, civil society. We can have this debate and not have any sort of scenes. With that, here's tonight's format. We're going to have 90-second opening statements from each candidate. We'll have 3 rounds of questions, and we will conclude with 90-second closing statements. We flipped a coin earlier to determine the order for opening and closing statements. Mr. Calvey, you'll go first in opening statements, followed by Mrs. Behenna. 90 seconds to you, sir.
Well, thanks to News 9 NonDoc, the Oklahoman, for hosting this event, for all those attending and all those watching. I'm running for district attorney to put the focus of the office on public safety and helping victims of crime, not political vendettas and not prosecuting for profit. We can't afford to let Oklahoma County go the way of other urban areas led by Democrat DAs like Los Angeles, which are infested with violence. No wonder poll after poll shows that on the issue of protecting public safety, voters by a large margin trust Republicans more than Democrats. I have many Democrat supporters who tell me I'm the only Republican they're voting for this year because they know that I will protect public safety and make needed changes from the DA's office. I prosecuted terrorists for the Army in a combat zone. The Army recognized my skill as a prosecutor by awarding me the Bronze Star Medal. The DA in an urban county like ours is an administrator who rarely prosecutes a case personally. The DA does 3 things: develops the culture of the office, sets office policy, and most importantly, the DA procures the resources to retain talented staff and lobbies for changes in state law to protect public safety. Where do those resources come from? And those policies? The legislature. Like it or not, our legislature is overwhelmingly Republican. As a Republican who knows most of those legislators, I know how to talk to them. My opponent has no idea what to do at the state capitol to get those resources or get those policies. As a Democrat, she'll be completely ineffective at persuading the legislature. If you want change in the system, you have to have a Republican DA to talk to a Republican legislature. For this administrative job as the DA, I'm far more qualified than my opponent. Thank you.
Thank you, Commissioner Calvey. Mrs. Behenna, 90-second opening statement to you.
Well, you just heard an opening statement by a career politician. NonDocs, thank you. Channel 9, thank you for hosting this debate. I am the only person running for district attorney that has experience as a prosecutor, and experience matters in this job. For over 30 years, I've been in the criminal legal system here in Oklahoma. I have made hundreds of charging decisions and hundreds of sentencing decisions. As I said before, experience matters. I am not a politician. I was a federal prosecutor for 25 years right here in Oklahoma City. I was assigned to the Oklahoma City bombing investigation, the worst domestic terrorist in Oklahoma or in the United States history. I was assigned by the Attorney General of the United States to join the Timothy McVeigh prosecution team. I was one of 2 Oklahomans on that team. I am driven to protect Oklahoma City. I am driven to protect public safety. I have been a defense lawyer now in Oklahoma City for 9 years. I have seen the criminal justice system from both sides. In addition to having defense experience, the dean of the law school at OCU asked me to head up the Oklahoma Innocence Project, which is what I've done for the past 9 years. I am the only person running for district attorney who has the experience to know how to bring charging and sentencing decisions.
Thank you very much. Round of applause to both candidates for their opening statements. Those of you who showed up in person, you're winning because we are having some Facebook cross-posting issues, but we're going to get that ironed out. Let's go to round 1. Storm, our first round is titled, Always Request the Information, which is also a great reminder for any young court journalist reporter out there. Always request the charging information. Each candidate will have 1 minute to answer each question. We will alternate who answers each question first, and I have the first question for you, Mrs. Behenna. You mentioned that you spent 25 years as a federal prosecutor in Oklahoma's Western District. What was the most challenging case you ever handled, and why?
Well, I think it would be the Oklahoma City bombing case, primarily because of the scope of that investigation. We worked with law enforcement partners, including the FBI, the ATF, state law enforcement partners, the OSBI, and Oklahoma City Police Department. So it was really a massive investigation where you had to assemble facts, digest those facts, and make decisions about what search warrants to issue, what arrest warrants to issue, and how to proceed with the case, such as what witnesses to call before the grand jury. So I guess that technically was probably the most challenging prosecution that I was involved in as a U.S. attorney.
Perfect. Thank you. Commissioner Calvey, you handled prosecutions while serving in Iraq. Same question, what was the most challenging case you ever handled and why?
Probably a bombing network, the Kar-Kursafa car bombing network, or VBED network as we called it. And what we were able to do there is working with special ops units, sometimes the FBI, and other 3-letter agencies. Some agencies that I'm not supposed to even mention their existence. We were able to get the captures from the special ops units and prosecute them. These are people who set off car bombs in the middle of crowded markets and murdered, dozens, if not hundreds, of women and children. And what we were able to do is Kark is the west bank of the Tigris River in Baghdad. Rasafa is the east bank. And we were able, through our prosecutorial efforts, to establish the link between them. We were able to locate one defendant who had served in cells in both things. The Al-Qaeda serves in kind of honeycombed types of situations where it's hard if you can bag one cell of them, you don't necessarily get the other ones. But we were able to find that missing link and make that happen.
Thank you very much, Storm. Next question to you.
This question will go to Mr. Calvey first. The debate tonight is titled Discretion Discussion, which is a reference to prosecutorial discretion. Tell the audience what that refers to and what is your guiding principle when it comes to making decisions as a prosecutor?
Sure.
60 seconds.
So absolutely, the goal of a prosecutor is public safety. Prison sentences are a prosecutor's most important tool. However, incarceration is not the goal. It's a tool. Public safety is the goal. The best result for public safety is not always a long prison sentences. You have to look at things on a case-by-case basis as much as possible. So we need to expand things like drug court, mental health court, veterans court, etc., not for violent offenders or sex crimes, but for drug court, for instance, only 7 to 12% of people reoffend within 3 years. That's a better track record than prison, where 50% are reoffended or rearrested within 3 years. There's a few other things we need to do in that office to make sure that we're doing the right thing. We need to help law enforcement in getting charges filed faster rather than making the cops file extra forms just for the convenience of the DAs. Push for better communication between the DA's office and law enforcement and DAs and defense counsel. That way we can expedite plea deals and other reforms to make the system work more quickly.
Mrs. Behenna, same question. What will be your guiding principle when it comes to making a decision where you to win this race?
Fairness. I mean, from somebody who has prosecuted cases for 25 years, what is most important is fairness. And what I mean by that is that prosecutors have to assemble evidence, review the evidence, and then make charging decisions based upon that evidence. You don't prejudge a case based upon what you think the defendant looks like or what zip code the defendant comes from. So prosecutors use prosecutorial discretion for those absolute and immediate charging decisions. Then prosecutorial discretion comes into play when you're making sentencing determinations. What should happen with this individual? Should they go to a diversion program? Do they need to be separated from society because they're a danger to society? That's what prosecutorial discretion is about.
Thank you.
Wonderful. Mrs. Behenna, I have the next question for you. State question 820 won't be on the November ballot, but it will propose decriminalization of marijuana on Oklahoma's next statewide election ballot. I think it's obvious why we're asking about this issue in a district attorney debate, so let's get right to it. Have you ever smoked marijuana or consumed cannabis? And will you vote for state question 820 to decriminalize the substance in Oklahoma?
You just go right for it, don't you?
Well, I thought I dreamed of asking this of the district attorney candidates, so why not?
Yeah, well, I can tell you affirmatively, I have never smoked marijuana or had cannabis. I know I'm kind of square, but it was just not my thing. I don't like losing control. I don't drink either. I don't like the feeling of not being in control of myself and my behavior.
What about the state question, though? Thoughts on decriminalizing the substance?
Hey, look, I mean, you know, the citizens of Oklahoma will decide whether or not that should be decriminalized. You know, I think there's been some evidence in the news recently about whether or not people who possess marijuana and use marijuana should even be charged. The citizens of Oklahoma County and Oklahoma actually will decide that issue.
Well, that's why we're asking you. You got to lean one way or the other? Because we're going to ask him too. Lean in one way? No? Okay, right.
You want to know what I would think about it?
Yes, ma'am,
okay.
yeah.
I would decriminalize for small use. I'm trying to think of the word, but for somebody that's just
personal
using,
use.
obviously not trafficking.
Okay, thank you. Commissioner Calvey, same question to you. Have you ever used the substance, and your thoughts on how you would vote on state question 820?
First of all, marijuana is basically legal now. And as a DA, I will treat marijuana businesses like I would treat businesses selling any other somewhat regulated substance like cigarettes. To the extent a business is out of compliance with laws governing legal marijuana, the administrative process should get them back into compliance. Marijuana businesses should not be subject to gotcha game prosecutions as they have been under the current DA. And I have a track record of standing up for people when they're being railroaded with the case of LaRue Bratcher, which I hope we can get the chance to talk to you in a bit. I will come down very hard on illegal operations led by foreign gangs and on hard drugs like fentanyl and meth. As far as that current state question, I have not read it, so I don't know how I will vote. I suspect it will probably pass. And I accept that, and that is okay. And I have two of my children in the audience, so all I will say about marijuana, I don't drink, don't use any substances now. The only thing I will say is, yes, I went to college. So.
Okay. And are you leaning one way on the state question?
I just haven't read it. So
okay.
I think it probably will pass, and I accept that, and we will adjust accordingly.
Your opponent, I'm not trying to dwell on the issue, but your opponent said she probably favors decriminalizing personal use amounts. Are you there, or are you opposed to that?
No, I think in principle, I think that's the right way to go. I haven't read the specifics of that state question to see what else is in there. That's my only hesitation.
Okay. Thank you, Commissioner. Storm,
All right.
Let's go to you.
I also went to college. In Oklahoma County, the district attorney has jurisdiction over the majority of state government. This question is for you, Mr. Calvey. The DA has jurisdiction over the majority of state government, including many actions of the governor and any action taken by the Oklahoma legislature. The question, has David Prater done a good job of investigating and prosecuting state corruption?
No. In fact, the Oklahoma County DA's office is the most corrupt office in state government. I have stood up to corruption, even in my own party, when I cross-examined two of Governor Fallon's inner circle as a member of the State House Special Investigations Committee back in the 2016-2017 era with regard to a major scandal at the health department. But we need to start, when you're talking about prosecuting corruption, you need to start at home, meaning in the DA's office, and get that out there. The problem with the DA's office now is far too often they will announce and investigate, and they've done it to people of both parties. I don't like Joy Hoffmeister, I'm not going to vote for her, but what he did to her in terms of releasing information about her right before an election and all that back several years ago was wrong. And that's what we don't want. I also think that we have I'll go ahead and call him the incoming Attorney General, the heavy favorite to win that, Mr. Gentner-Drummond, who has said he himself wishes to take a major role in investigating that corruption, and I think he will do a good job as well.
Ms. Behenna, same question. How will you tackle state government, and what grade would you give Mr. Prater on this?
Well, let me just answer the question about what I would do with regard to issues and investigations involving public corruption. When I was in the U.S. Attorney's Office, I actually did prosecute, not question, but actually did prosecute a number of cases involving corrupt public officials. I am well versed on how to tackle those investigations, and more importantly, how to investigate those cases. I've actually prosecuted members of my own party when I was in the U.S. Attorney's Office. Those are very complicated investigations that require much investigative experience. I think that the district attorney for Oklahoma County, that obviously sits in Oklahoma County, maybe working together with the Attorney General, if they have the experience to handle those kinds of investigations, we might work those cases together. But I will not shy away from a public corruption case.
Wonderful. Now, I thought I heard some beeping. Am I the only person who heard beeping?
No, I heard it too.
And is it gone? Okay. Do we know what caused it? No. Well, I didn't think you would in the front row. I was talking to the people in the back. Okay, well, if it happens again, we'll just kind of pause for a minute because I don't think it's fair for anybody to answer with something like that. I feel like I'm still hearing it in the back of my mind. I do have a follow-up question for both of you regarding corruption cases. One of you will likely inherit some high-profile prosecutions regarding, among other things, Epic Charter Schools, State Representative Terry O'Donnell, and Seaworth Academy, a closed charter school whose board members included a judge and a state senator. Mr. Calvey, first question to you. You have said you would recuse from the Epic case because you were paid for some legal work by the school. What exactly did you do for Epic?
Well, due to attorney-client privilege, I can't say specifics. What I can say is that it had nothing to do with the matters for which there had been a publicly announced, charge against them. Nothing to do with that. It was after I had left the legislature, long before I decided to run for district attorney. My connection with Epic is that 6 of our 7 children are students at Epic. But just like for any other of the, few hundred clients I've represented over the years, if a case came up involving them, I'd have to recuse as well. That's just a simple matter of legal ethics. So I would kick that one up to the Attorney General's office, and they would decide what to do with it. For the other ones, there'd be no legal bar for me doing it, and we'll certainly, again, work with the Attorney General, who I think will be Gentner-Drummond, because he has expressed a very strong concern in taking the lead on looking at public corruption cases. So I'd work it out with him as to who would proceed and go from there.
General type of law that you did for Epic, was it a contract thing? Was it real estate?
Yeah, it was transactional.
Transactional? Okay, thank you very much. Ms. Behenna, Mr. Calvey has been endorsed in his campaign by House Speaker Charles McCall. He sort of referenced this a little bit. And Mr. McCall was a key witness for the grand jury that indicted Representative O'Donnell. Mr. Calvey said in June that he is not legally required, he just said that again, to recuse owing to Mr. McCall's endorsement, but that he might consider it depending on McCall's testimony. Put yourself in his shoes for a minute, and Mr. Calvey will let you respond as well. Would you recuse if, from a case where a witness in that case endorsed your campaign?
My gut reaction is yes, for this reason. The appearance of impropriety is important. And lawyers have to, we understand that. We understand that we cannot have the appearance of being in conflict. The issue with regard to this kind of a question, and that is recusal, has to do with whether or not the general public determines that the district attorney's office is operating fairly for everybody. Right? And that's what I'm talking about, that appearance of impropriety. If people feel that some people are getting a better deal, if some people believe that a person is getting a better sentencing recommendation because of a relationship that a district attorney has, that the district attorney needs to recuse himself from that case, because people need to have faith and trust in the criminal legal system.
Mr. Calvey, 45 seconds to you. The O'Donnell case, Speaker McCall's endorsement, your thoughts?
I'm endorsed by thousands of people. If a DA had to recuse for everybody that endorsed him, you'd have to recuse from I mean, hundreds of cases. So no, I don't think there's any inherent bar to it. What I would do, again, in that situation would be to discuss it with the Attorney General and jointly make a decision on where to go from there.
Is it a factor, I thought of this last night, is it a factor there were two bills about tag agencies that resulted in that indictment?
I actually don't know. I haven't.
Well,
I
you voted for one of the bills in 2018, so I was
Okay.
curious whether that factors in as well.
It could, I suppose. I wasn't aware that that was one of the bills that was being discussed.
I thought of it like at midnight last night. Okay, that's the end of round one. Thank you so much. Give a round of applause to the candidates. Remember, now is still a good time to share that News 9 Facebook page stream. Storm, you have the next question. Round two, let me say, is it's titled Death and the Jail. It's a little bit of a morbid moniker, but this is where we are as a society, so buckle up and prepare for 90-second answers from questions. Storm has the first question, but Janae Williams of the Oklahoman will join us on stage here in a few minutes. Storm.
Mr. Calvey, this one goes to you first. As a prosecutor in Oklahoma, you would have the ability to seek the death penalty as a punishment for someone convicted of first-degree murder. During your time prosecuting cases in the military, you did pursue death sentences in certain cases. Would you pursue the death penalty in Oklahoma County cases? Why or why not? And if so, when?
Sure. So first of all, I did obtain several death sentences against terrorists in Iraq. Obviously, I think the death penalty is warranted in some circumstances, but I don't think it should be used often. People like cop killers, terrorists, we do need the death penalty for them. But I think it should be recognized that the death penalty is a very drastic solution and one that is potentially very expensive and lasts a long time before you can get a result on it. And so I don't think it should be used lightly.
Ms. Behenna, you have been a federal prosecutor, but you're also the director of the Innocence Project at OCU Law School, so you're aware that wrongful convictions have occurred in the past. Would you pursue the death penalty in Oklahoma County cases? Why or why not, and if so, when?
This is a very difficult question and a very difficult decision for somebody who has been a prosecutor to make. As you know, I was involved in the Oklahoma City bombing case, and we made the decision to pursue the death penalty in that case. I think where there is a particularly heinous crime that has been committed, the death penalty should be considered, not in every case, but the most heinous of crimes, but only after the evidence in that case and the background of the defendant are reviewed. In other words, before we did it in the Oklahoma City bombing case, we had a roundtable with professional prosecutors to make that weighty decision. So, would I use it in every case? Absolutely not. Would it be on the table in most heinous of circumstances and rarely used? Possibly, depending on the evidence and who the defendant was in front of me.
Quick little note from our photog, just make sure we're speaking into the mics when we're answering questions, so for the folks watching at home, again, you can still share that stream. I do have a follow-up about the death penalty. Quick question for both of you. Two high-profile death penalty cases from Oklahoma County have drawn headlines all these years later. Do you believe Julius Jones was rightly convicted in the murder of Paul Howell? And do you believe Richard Glossip was rightfully convicted in the murder for hire of Barry Van Treese? Who wants to answer first?
I'll be happy to. I don't know the facts of those cases. I don't. I am smart enough and have enough experience in the criminal legal system to understand that mistakes happen. I don't know the facts well enough in those cases to know whether or not they were wrongful convictions. But it does, we all have to recognize that while we have a good criminal legal system, it is not perfect. And it merits review, and if somebody is facing the death penalty, we better be damn sure that we've got the right person and the evidence to prove it.
Commissioner Calvey, same question to you.
I also don't know the facts of those cases. I did in the Julius Jones case. I actually did suggest publicly that the case should be granted clemency for this reason, not because I think that Julius Jones is innocent of the crime, but because that process had been tainted by the current DA when right before the Pardon and Parole Board was going to make a ruling on that case on whether or not to grant clemency, the current DA filed a bogus grand jury against the Pardon and Parole Board. That was a bullying tactic, something right out of a Banana Republic. And I said so. I called the DA out on that and did suggest and call for that Julius Jones be granted clemency, not be released from prison, but be granted clemency, and that's what the governor did.
Storm, next question for you.
This question will begin with Ms. Behenna. The U.S. Supreme Court's decision in Dobbs v. Jackson this year necessitates our discussion of abortion tonight. In preparation for this segment, Trace asked a healthcare lobbyist to help us understand the current state of state laws. There are several state laws in effect now. He was told some healthcare lawyers don't want to put anything into writing because of potential legal challenges. The question: what is your interpretation of the current Oklahoma laws regarding abortion, and what decisions do you foresee a district attorney having to make?
Well, I think the Attorney General of the state of Oklahoma has issued an opinion about the new law, and I assume it's not a formal AG opinion, but it is something that he has given to law enforcement and district attorneys to follow. So that's the guidance, at least from the Attorney General. I mean, if I can address just briefly the laws that we've passed here in Oklahoma, I believe it is pure and simple overreach by the government to issue those laws. I've been talking to doctors throughout Oklahoma County, and they are concerned that their medical judgment has been usurped by the state government. I heard a story from an OBGYN who was telling me that a woman, her patient came to her at 21 weeks and her water broke. She was not permitted to terminate that pregnancy because the fetus had a heartbeat but was not viable outside the mother. She had to wait until the mother developed an infection before she could terminate the pregnancy. I believe, as I said, that these laws well overreach in making medical judgments by physicians.
Mr. Calvey, 90 seconds, same question.
Okay, so I'm Catholic, I'm pro-life, and I do not intend as DA to have to prosecute abortions, and here's why. So last spring, the abortion industry in Oklahoma mostly shut down, with some exceptions, as a result of abortion laws passed by the legislature that provide for enforcement by civil lawsuits from private parties. The DA's office is prohibited from involving themselves in those lawsuits. Here's what the practical result of these laws is. Women can still obtain a legal abortion for any reason about 2 hours away in Wichita, Kansas. Abortion is thus less convenient than before, but hardly impossible. I doubt an Oklahoma doctor is going to risk a civil lawsuit, losing their license, etc., to do an abortion illegally when there is a legal alternative not far away. So will I prosecute a woman for seeking or obtaining an abortion? No. Will I prosecute a woman for traveling to another state to obtain an abortion, or someone who assists her in doing so? No. What an Oklahoman does in another state is up to that state's laws, not Oklahoma's laws. I have many supporters for my DA campaign who know I'm pro-life, but they also support abortion rights. They recognize I'm very practical in my approach. Abortion just really won't be an issue at the DA's office. I will continue my lifelong advocacy for more resources for pregnant women in need. I have long donated my money and my volunteer services as a lawyer to pregnancy resources and the women they serve. And in the legislature, I've championed for more state resources for pregnant women also. And that is what I will continue to do.
Mr. Calvey, I do just want to be clear on this one question. Correct me if I'm wrong. I understood you said you would not prosecute someone who aids another person in receiving an abortion. Is that correct?
Aids somebody in traveling to another state to obtain an abortion. Correct.
What if somebody performs an abortion here, though?
If somebody who's not a doctor performs an abortion here or administers abortion drugs, oh yes, we should want to prosecute anybody who tries to usurp the role of a doctor, whether it involves abortion or not.
Well, let's assume it's a doctor. Let's assume it's a medical doctor.
I'll be honest with you, I just don't think that's likely to happen because they're already risking civil lawsuit and things like that. So I would be inclined to not intend to do so.
But you might.
I would not say never. There's all kinds of factors that could be involved, but it would be my intent not to.
Mrs. Behenna, or Storm, I guess this is your question. Don't let me get in the way.
Do you have any?
Well, I mean, I'm glad to hear that Mr. Calvey says that he's not going to prosecute any women that seek an abortion. I think that's the right answer, and Oklahoma law doesn't provide for a DA. Even the AG has said that women who seek an abortion are not going to be prosecuted under these new laws. But it's much more clouded than that when you're talking about OBGYNs who are caring for women who are pregnant, who have issues with regard to their pregnancy, and whether or not those people would be prosecuted. Again, I think it is government overreach. I think that we have stepped into an arena, we, the government, the state legislature and the governor of the state have stepped into an area where they should not be.
And so, just to be clear, would you prosecute a woman who sought an abortion here in Oklahoma where it would not be legal, or in Kansas?
No.
Would you prosecute a doctor who performed an abortion in Oklahoma?
I agree. I don't think any doctors are performing abortions here in Oklahoma, so I don't think that's an issue.
If they did?
I mean, we're talking hypotheticals. I would want to know the facts and circumstances surrounding that abortion. Is he just setting up a shop down the street? Or is he terminating a pregnancy because that child or that fetus is not viable? All those facts matter in making those decisions.
Thank you very much. Storm, I think we're going to have Janae Williams join us on stage here. Give Storm a round of applause. And give Ms. Williams a round of applause. Janae, thank you so much for being here. Thank you for the Oklahoman for being a partner on this. This is our first time partner on one of these. I hope it continues. Janae covers Oklahoma County, and she has a pair of questions regarding the long-beleaguered county jail. Janae?
Thank you, Trace. Ms. Behenna, a recent report from Forward.us found that people detained on felony charges in Tulsa County are released on personal recognizance bonds at a rate 5 times that of those detained on similar charges in Oklahoma County. What would your role be as district attorney in closing the gap, and are there any specific changes to bail and bond that would better serve the public?
Yes. Yes, there are. I believe the Oklahoma County Jail is full of people who cannot afford to bond out. That needs to change. So with regard to individuals who have been charged with low-level offenses that are nonviolent, who don't have a history of violence in the community, they're not a danger, and who do not have failures to appear, those individuals should be allowed to an OR bond or a personal recognizance bond, clearly. With regard to individuals who are a danger to the community and or flight risk, have other previous failures to appear, that's a different matrix. So the district attorney's office and the public defender's office does have a bond schedule. That bond schedule has not been reviewed in years. I've talked to the public defender about revising that bond schedule to give more transparency on the bond amounts for the particular offenses, but for certain people, we need to make sure that we individualize that bond. In other words, if the person is not a danger and not a flight risk and does not have failures to appear, then they should be allowed a reduced bond amount so they can continue to work and support their families.
Mr. Calvey, same question to you.
Any reforms we do with our criminal justice system must prioritize public safety. We will not have soft on crime policies like the Democrat DAs in places like Los Angeles. We do need to keep jail and prison for public safety, not a debtor's prison. There are too many people in jail over fines and fees. I don't think the jail is full. I think most of the people in the jail at this point, after some years of some reforms in this area, are people that do need to be in jail. But there still are some. That is correct. Let me give you a case in point. Fines and fees. For people that are facing a conviction and they're ordered to pay fines and fees, especially the $991 DA supervision fee, a lot of times they're required to go back to court every so often. If they miss even one time out of 12, a warrant is issued for failure to appear. That would be one where I don't think somebody ought to go to jail for that. That would be one even on an FTA. Depends on what the FTA is, failure to appear, on whether or not they should go there. We're actually spending more to jail some of these people than we're collecting in the fines and fees. That's not fiscally conservative or humane. I'm also told 20% of the people going to prison are for revocation of a sentence on some sort of technical violation, sometimes because they can't pay for some program they're ordered to complete. The very first goal is to lobby the legislature for full funding up front of the DAs, judges, and public defenders. That will take away any incentive to prosecute for profit. And again, our legislature is overwhelmingly Republican. I'll be effective in talking to him. My opponent won't.
Let me ask a quick follow-up real quick. Commissioner, you sort of implied that Democrat DAs around the state or around the country, are you implying that Ms. Behenna is going to be dramatically different than you on this topic? Is there somewhere where you guys are different?
On this particular topic, I don't know.
Okay, Ms. Behenna, are you going to be different than Commissioner Calvey on this topic?
On cash bonds?
On cash bonds, on the amount of OR
but
used?
it's a nice label he can place on me, right? I mean, that's what it's about. He can't attack my experience, so he's got to try to place a label on me.
Mr. Calvey, you say you want to improve a corrupt DA's office, but many people say the Oklahoma County Jail and its administration are corrupt, or at best, inept. You've been a member of the jail's governing body, the Jail Trust, since its inception, but we typically have not seen you ask tough questions of Jail Administrator Greg Williams during Jail Trust meetings. So tell us specifically, what actions have you taken to address the increase in jail deaths, sexual assaults, and other troubling events?
So first of all, I asked my tough questions not up on the horseshoe, but one-on-one with Mr. Williams and his staff. So my goal as a county commissioner was to get a new jail without a tax increase. Thanks to the voters, that will now be a reality, and that's going to solve a lot of the problems. None of that would have happened without the jail trust. The last time a jail vote occurred on whether to fund a new jail, it only got 15% support and 85% against. People did not trust the former operators of the jail. They were taking money intended to fix the jail and spending it elsewhere. The jail trust is more transparent. That's why you still see news about it. The former sheriffs got the Black Hole Award from Freedom of Information Oklahoma for not releasing that. There's over 80,000 pages of records of violence in the jail that were never released to the public. So violence is way, way down in the jail from what it was. It is not perfect, but they're making progress. You can't solve 30 years of mismanagement in just a short time.
Hey, hold on, just be respectful of our moderators here. Let's have this discussion. Janae.
Ms. Behenna,
Well, I would like everybody to stop. Listen. Just one question. I will have Deputy Bellinger remove folks if we have disruptions, so I'm doing my best up here to be fair. I think they both think we're doing a good job, so Janae, let's go back to you.
Ms. Behenna, do you support the Jail Trust's continued operation of the Oklahoma County Jail, or do you believe control would better be placed in the sheriff's office? Why or why not?
Yeah, well, I was at an FOP meeting with many deputy sheriffs, and I can tell you they don't want the jail back. It is a mess, right? I mean, I am not involved in the jail trust. I've not gone to any meetings involving the jail trust. Something has to change with regard to the operation there at the jail. I know Mr. Calvey wants to blame his predecessor and the people that came before him, but quite honestly, more people have died this year alone in the Oklahoma County Jail, and there has been more contraband introduced in the jail just in the past year. I will, as the district attorney, get involved in understanding what's lacking in the jail trust and the operation and make sure that safety of the inmates there, most of these are pretrial detainees. These are not people that have been convicted of any crimes. These are people that we presume to be innocent until proven guilty. They should not be dying in the Oklahoma County Jail.
I want to talk about this a little bit more, Mr. Calvey, 30 seconds
That's one thing to say.
Yeah.
So, first of all, the reason most of the people who die in the jail do is because they're about on death's door when they're brought to the jail. It used to be that the DA's office would approve more medical OR bonds. The jail staff tries to get people medically OR'd out, and now, because the current DA does not like the jail trust, he is denying those. That is a big part of the problem.
Well, there's other issues that have happened, right? We've had at least one publicly reported, and I believe a second recent potential sexual assault involving people who were being booked into the facility. We had the hostage situation earlier this year. We've had numerous deaths. There's a civil lawsuit regarding a man who was nearly beaten to death and who, after he got out of the hospital, was put back in the cell with the individual who nearly beat him to death. I would like to know what questions you ask Mr. Williams in private.
First of all, the problem in really any jail, and our jail is no exception to it, is staffing. Staffing is a problem for businesses all over the country. It is not unique to the jail and corrections industry. Our jail is not alone in having these kinds of problems. The more that you are able to get staffing up, and I've been a champion for increasing the pay of jail guards to make sure that that happens. I will tell you, statistically, the violence in the jail is way, way down, especially staff on inmate violence, but also inmate on inmate violence than for what it used to be.
Mrs. Behenna, 30 seconds if you want it. Does the DA need to do something? Mr. Prater would argue that there needs to be some more accountability. He asked for a grand jury investigation. That's being handled by Mr. Thorpe out of Cherokee County. What are your thoughts as you watch
Look,
on?
I mean, it is a crime for somebody to bring contraband into a detention facility. Those things need to be investigated and prosecuted. It is a crime to allow sexual assaults and rapes to occur in the general intake area. Somebody is not supervising properly. There's no excuse for that kind of behavior in a facility that's a detention facility that is run by alleged detention officials who are watching and ensuring safety of the inmates that are there.
Wonderful. Thank you. We've reached the end of round, 2? Give Janae a round of applause. Thank you so much, Janae. Storm, she's coming for your job. We're going to go to round 3, courtroom etiquette, and I appreciate you all being passionate about these issues. That's why we're asking so many follow-up questions, but we appreciate you letting the folks at home still be able to listen without too many outbursts. Janae, great job. Storm, we're going to go to our 3rd round, and I guess I have the first question.
Let's
I thought
do it.
you did. Oh, okay. This is where we ask candidates about their records, their backgrounds, and statements. Mr. Calvey, first question to you. You announced your campaign with a blanket promise to drop criminal charges against the Oklahoma City police officers who fatally shot 15-year-old Stevian Rodriguez after he attempted to commit an armed robbery. You've called those charges, quote, malicious, and have said you would dismiss them on day 1 in office without reviewing the witness statements, officer statements, or other evidence of the shooting that would be available to you once you became district attorney. How do you respond to people who say it's irresponsible to announce a case decision without first reviewing all documents, videos, and interview transcripts?
Here's what's irresponsible. When you file a criminal charge against somebody, you should know that you can prove that charge beyond reasonable doubt. Here's what we do know about that case. The Oklahoma City Police Department did investigate it and found that the shooting was justified. And number 2, the video from the case clearly shows that the armed robber, the violent felon whom they encountered there, disobeyed orders to keep his hands up and reached behind him as if he was going for a weapon. I will support our police, not persecute them. Our current Democrat DA is wrongfully prosecuting these officers. Wrongful prosecutions of police officers demoralize the police, they harm recruitment and retention of police officers, and make them less likely to put themselves in harm's way. And that makes all of us less safe. My opponent has attacked me for standing up to these police officers. That's because she plans to prosecute those officers to cater to anti-police sentiments in her own party, like the Democrat city council members who voted to defund the police. I will dismiss the charges against those officers. I'll look at the file, but unless it says, hey, whoopee, we get to go kill somebody today, I'm still going to dismiss the charges. There's no way you could prove felony charges against those officers at all, much less by reasonable doubt. The responsible thing to do would be never to have filed those charges to begin with and to dismiss those now. It's a matter of standing up for not only those who protect and serve us, but creating public safety. When you undermine the police with wrongful prosecutions, you end up making all of us less safe. When they that doesn't mean I wouldn't file a charge against an officer ever. It's a different matter when police harm somebody in custody or an innocent person, things like that. But when faced with a known threat, when they only have seconds to react, we shouldn't be prosecuting officers for just doing their job. I will support our police, not persecute them.
Thank you. Mrs. Behenna, 90 seconds, similar question to you. What's your reaction to Mr. Calvey's decision or statement that he would drop those charges right off the bat? And what are your thoughts on the Stevian Rodriguez case and the Benny Edwards shooting?
Well, I think, quite honestly, Mr. Calvey's statements are pandering to law enforcement in order to get their vote. Nobody in their right mind who has ever prosecuted a case would look at a video on TV and decide that those charges were not proper. That's what makes him so dangerous as a district attorney. There is all sorts of evidence involved in this case. I don't know what it is. I've not seen it, but I understand body cam footage taken from different views might substantiate that it was an unreasonable use of force. It is absolutely improper to pander to a group of people to get elected, because I guarantee you the minute after, if he were to win this seat, he would be filing charges against police officers, because if police officers act outside their training and experience, those cases need to be reviewed. Those cases need to be brought. My husband is a career law enforcement officer. I understand fully the difficulty that cops have on the street. I am not saying that I would charge every police officer. I'm going to tell you exactly what I told the FOP. It is improper for anybody to prejudge a case without knowing the facts, because in prosecutions, facts matter.
Mr. Calvey, I'm going to give you 30 seconds to respond to that. It does strike me that when I asked you about the O'Donnell investigation and Speaker McCall's endorsement and those sorts of things, that you said, well, you didn't know the facts and you wanted to wait and review the matter. And in this instance, you say that you have enough information to make that decision. So
we do. There's
the
two
difference?
things. Number one, the Oklahoma City Police Department did review the case and found that the shooting was justified. And then there's video which clearly shows that the guy who was a known violent felon provoked the officers, and they acted in self-defense and defense of the prosecutors. What's really terrible is for you to pander to these anti-police people like the Democrat City Council people that voted to defund the police in your own party. That's what's a problem. And you have to know you're going to be able to prosecute that case and win it beyond reasonable doubt. And there's no way, none, that case could be proven beyond reasonable doubt. So therefore, it should be dismissed.
May I respond?
Yes, ma'am.
First of all, Mr. Calvey, if you were a prosecutor, you would know that the standard to bring a case is not beyond a reasonable doubt. It's preponderance of the evidence. That's the standard. And why would I defund the police when my husband was career law enforcement? He made a career working at taxpayer expense. I hate to say it like that, Scott. But he was funded by taxpayers to do a job, and he did an honorable job, as did all the other police officers and agents that worked with him.
So quit prosecuting them for just defending themselves against known violent felons.
Okay, we've reached the end of that exchange. Storm, I believe you have the next question.
All right, this question will be asked to Ms. Behenna, and Mr. Calvey, you'll have an opportunity to add your comments. Ms. Behenna, your son was charged and convicted for a homicide while serving in the military, and you advocated for him to be pardoned, which President Donald Trump did do in 2019. Currently, as we mentioned this evening, 7 law enforcement officers are facing felony charges for citizen deaths here in Oklahoma County. Question, is it possible those scenarios could make you think about your son's case? And how would you convince voters that you would not be biased in considering cases of law enforcement-caused deaths?
I am a career prosecutor who understands the criminal legal system needs to have a prosecutor who understands that you follow the evidence first and make charging decisions based upon that evidence. Do I feel empathy for people that enter the criminal legal system? Yes, I do. Do I feel empathy for victims that didn't want to be in the criminal legal system, but somebody had violated them or committed violent acts against them that make them enter the system? For 25 years, I reviewed facts to make charging decisions. Police shootings involve not just the facts of the case, but we're now talking about technical issues about whether or not excessive force was used. I have hired and retained experts before to help me evaluate the facts. If a use of force expert in a police case says to me, this is reasonable force, Vicki, and we should not prosecute it, those cases would not be prosecuted. If a use of force expert tells me that the use of force was unreasonable for those facts, then that is a case that I would bring and would prosecute as a DA.
A military prosecutor did go through those questions, and your son was convicted and pardoned. Do you think that that would affect your judgment in making such charging decisions?
No, because I follow the facts.
Mr. Calvey?
Well, I would say, first of all, I'm glad that her son was pardoned. I understand the stresses of being in a combat zone, and people sometimes do things they otherwise would not do when over there. So I'm glad that he was pardoned. But it is awfully hypocritical to go and beg for mercy for your son and then not have any mercy for police officers who are under a much more constrained time frame. And when they were responding to a direct known violent felon who was threatening them, we should take these things into account. It's almost like a combat situation, I think, for an officer when they're in that situation under threat, and they should be given leeway on that, and they should not be prosecuted for simply doing their job when they're under threat from a known violent felon.
Ms. Behenna.
It is irresponsible to make that statement without reviewing facts. That makes you so dangerous as a district
I want to say one other
attorney.
thing. You said a minute ago something very shocking. You said the standard for convicting somebody on a felony charge is preponderance of the evidence.
No,
oh, no.
no, you
That's the
misunderstand.
standard for a civil case. The standard to
no.
prosecute and convict a person on a case in which there's a felony charge is beyond reasonable doubt. If you don't think you can finish that case and convict them beyond reasonable doubt, you shouldn't be filing the charge.
I'm talking about bringing, may I?
Please,
I'm
let's
talking
hear what
about
they say.
charging decisions. I'm not talking about conviction. Of course, that's reasonable doubt. But the decision that a prosecutor makes is not looking at whether or not I'm going to be able to prove it beyond a reasonable doubt. They determine whether they have sufficient evidence to bind somebody over and to prove that that person committed the crime. The jury makes a decision on whether or not the proof was beyond a reasonable doubt.
You shouldn't be running cops through the ringer based on anything less than you think you're going to win that case on a reasonable doubt. It is undermining public safety when you do so.
All
Ms.
righty.
Behenna, final 15 seconds if you want it. We good? Okay.
This
Storm.
question will begin with Mr. Calvey, and we'll do the same kind of exchange. Mr. Calvey, you called an August press conference in front of David Prater's office to allege that he improperly and politically asked the OSBI to investigate concerns about a contractor your office used for official county work, who's also employed by you for campaign work. The question: have you been contacted by the OSBI, and if you were in Prater's position where allegations were made against someone running to succeed in his office, would you not have acted similarly by referring the matter to another agency?
So this was nothing but a political hack job by David Prater, which he's done to so many people so many times. I've been very critical of the current DA, David Prater. He unethically requested this investigation of me. What he should have done is simply said to people that were saying anything about me, go talk to the Attorney General's office. And then the Attorney General would decide whether to farm it out, ask for an investigation, etc. Instead, he did it and then managed to get that leaked to the press right before my runoff election, which so happened to be against one of David Prater's cronies. My opponent has said that anybody in investigation should not be the DA. That's a shocking violation of due process. She said that in the news right after the runoff. God help us if she becomes DA with that lack of respect for the presumption of innocence. Maybe she'll change her tune when other things start getting investigated. The OSBI tells me they are done with their investigation. They did talk to me. It's clear that they realize the allegations are false. This was nothing but a political hatchet job by David Prater.
Ms. Behenna, 90 seconds.
Will you repeat the question again? He kind of.
Yeah, the question was, if allegations were to be made against someone running to succeed you in office, would you have not acted similarly by referring this matter to another agency? Mr. Calvey has obviously defended himself and said this investigation is a political witch hunt.
Right.
Do you support his summary of the facts?
Well, I don't know the facts, and I don't know why he called a press conference to announce the investigation. But if there is an issue regarding, again, the appearance of impropriety, whether or not it involved, if I had been David Prater and there was an investigation about an opponent and when Galen Gigger was in a runoff with them, I definitely would have referred that to somebody else. Again, we need to have people have confidence in the criminal legal system, that investigations are being done for a proper purpose and not for a political gain or personal gain. And so, yes, I would have referred that investigation outside of the office as well.
What about the statement that Mr. Calvey raised? You were quoted saying that someone under investigation should not be elected to public office. Do you support that notion?
Well, I don't remember saying that.
You were
but
quoted in the
gosh,
paper.
I mean, if you're under investigation by the OSBI, it questions to me whether or not you can properly make charging decisions that need to be made in the DA's office.
Well, that's a shocking violation of due process. Anybody can call for an investigation. You don't even have to have any proof. You don't have to have probable cause or anything to call for an investigation. God help us if anybody, you can just say, you're under investigation, you're under investigation, you're under investigation, and then all of a sudden, you're going to jail or you're not eligible for some, public office or, some appointment or something like that. Investigations are merely that, and that statement was very reckless of you and not at all consistent with the constitutional rights that are protected for all of us Americans.
I have one quick question, Mr. Calvey. You said that you again alleged that Mr. Prater alerted the media, in specific Nolan Clay of the Oklahoman was the one who was calling you about it. Mr. Clay has said that he was not contacted about it by Mr. Prater.
Not directly.
So you believe it was still...
Yes, it was
Mr.
certainly
Clay
engineered by David Prater. It's his MO. He's done it for years and years.
Appreciate your time. Ms. Behenna, I have the final round of this question. Final question of this round. You and your other son, Brett, represent Bobby Chris Mays, the former owner of Big Red Sports and Imports and other car dealerships.
Yes.
Mr. Mays and a woman named Courtney Wells and a third co-defendant were convicted of wire fraud, conspiracy, forgery, identity theft by a federal jury. I'm not making this up. While the case awaits sentencing, you filed a motion seeking a new trial on purportedly new and exculpatory evidence, a folder of printed emails that indicate Ms. Wells apparently led the scheme without Mr. Mays' knowledge. Prosecutors don't necessarily believe that's the case, but subsequently Ms. Wells and her new husband have disappeared, abandoning their teenage daughter. In responding to your motion, those prosecutors say that the series of emails cannot be authenticated and, quote, simply do not look anything like actual previously authenticated emails from Ms. Wells. Prosecutors also wrote that the, quote, only person who benefits from Ms. Wells' inexplicable disappearance is Mr. Mays. Question is, if you truly believe these emails that you filed are authentic, how did you and your co-counsel not discover this exculpatory evidence for the past 2 years? And what do you think happened to Ms. Wells?
Yeah, I'm happy to answer those questions, at least as far as the evidence is in public documents, okay?
Sure.
So if you had read all the documents in the case and all the filings, you would know that the case, we went to trial last November. There were allegations of prosecutorial misconduct in the case. As a matter of fact, we had to file 2 motions for a mistrial as a result of prosecutorial misconduct. Many motions have been filed in that case, including motions for sufficiency of the evidence as a result of sufficiency of the evidence, I can't even talk now, and prosecutorial misconduct. I don't know where Ms. Wells is, but I venture to say that she left because she told many of her cohorts that she was going to leave as a result of her sentencing. She said that she would not serve a day in court. As a matter of fact, I think before she left, we are now discovering that she was assigning her property, her home, and other assets that she had to her daughter well in advance of when she left. If you're trying to insinuate that somehow I was involved in doing some things to assist my client, I will tell you this. I would not have survived 30 years in this legal community and have the reputation that I have with judges and my fellow lawyers without first verifying and authenticating evidence presented to a court. You would know, if you had read the public filings, that there was a document expert, a document examiner that reviewed those emails, validated and verified those emails before they were presented to a court. And I can tell you, if an Article III judge thought anything inappropriate was happening, I would have heard about it from the judge.
Prosecutors argue, I did read the documents. The prosecutors argued that he was not an expert that was qualified to make that determination. Before we get to Mr. Calvey's response, what was the allegation of prosecutorial misconduct? Since we are running for a prosecutorial position, I was curious.
Sure. The prosecutorial misconduct was improper questions that were asked on cross-examination in which the prosecutor had no reasonable basis in fact to ask those questions. So it's an ethical issue with regard to prosecutors. They can't ask questions that they don't believe there's any truth to it. The judge admonished the prosecutor and referred her for investigation by the Office of Inspector General at DOJ. There is now yet, if you would know that, we filed a motion last Thursday for yet another continuance of a hearing because information that has recently become available, again insinuating that the prosecutors withheld over 300 text messages from the defense that they had in their possession, but before the case went to trial. That's another allegation of prosecutorial misconduct. That would be a Giglio violation of which the prosecutor should have turned that evidence over so that we could have used it for cross-examination.
Thank you very much. Mr. Calvey, 90 seconds, your reaction to this situation.
Well, first of all, kudos to Sylvia Corkill at News 9 for breaking the story last night. 2 Oklahomans are missing and may have been murdered because Vicki Behenna was willing to submit fake documents to a federal court to get her crooked client out of prison. These are the facts, according to the U.S. Attorney's Office. Her client, Chris Mays, was convicted last year. May 2nd, Courtney Wells, also a co-defendant and an employee of Chris Mays, and her husband have been missing. That was, by the way, a few days before her only daughter's high school graduation. Who goes on the lam at such a time? Nobody. A few days after that, Ms. Behenna filed a motion for new trial for Mays based on what the U.S. Attorney's Office says and has abundant proof of are fake documents that Behenna submitted to the court. These fake documents could only be corroborated by Wells, who was conveniently missing. As the U.S. Attorney's Office said, Ms. Wells had no incentive to go missing, and the only person who benefits from her disappearance is Mays, Behenna's client. The U.S. Attorney's Office implies that Mays caused Wells' disappearance. And yes, that document expert is a schlock, as the U.S. Attorney's Office points out. It's very hard to stay missing for 5 months, so sadly, it seems unfortunately likely that Ms. Wells and her husband are dead. For the sake of the safety of other witnesses in the case, Chris Mays should be taken into custody or at least made to wear a titanium ankle monitor right now. The question Oklahomans are increasingly going to ask is, where is Courtney Wells? My opponent's actions in this case are a stain on her record. Even in the unlikely event that Ms. Behenna were elected DA, she'd have to be removed from office soon thereafter because of this ethical stain.
Ms. Behenna, let's have you respond.
Yeah, you know, it doesn't surprise me that Mr. Calvey would make these statements. He is a career politician who has created a false narrative for his own political gain. This is something politicians do. This is not something a district attorney does, because you cannot pick and choose facts that you want to listen to, Mr. Calvey. Why don't you review all the pleadings in the case and find out what all the evidence is, and before you start creating false narratives for your own political gain?
I didn't create the narrative. I'm just quoting the U.S. Attorney's Office in this case. It is very dangerous. And this case is a stain on your career, and you would be removed from office if you happen to get elected.
I can't hear what was said, so I don't know, but maybe, hopefully the journalists can. We can go back to the tape. Any final thoughts, Ms. Behenna, Ms. Calvey, on that matter? It looks like a maybe.
Well, I'm trying to think about how to say this. I mean, it is shocking to me that Mr. Calvey would issue a press release. I mean, he tried to peddle this story to 2 other news sources who didn't pick it up, because what he was peddling, again, was a false narrative based upon bits and pieces of what he considers to be facts. He is a dangerous person for a district attorney's office. If he will do this to win an election, what is he going to do in the district attorney's office when it is important for the district attorney to have the integrity and be above reproach and not create false narratives for your own benefit?
Mr. Calvey, 15 seconds, finish this
Again,
out.
it's
Real
the
quick,
it's what the U.S. Attorney said, and what's shocking and dangerous is that you would submit fake evidence, fake documents to a court, and that as a result of that, your complicity in that, 2 Oklahomans are missing and probably murdered. That's shocking, and that is shocking.
May I respond?
Yes, ma'am, yes.
He has no idea what he's talking about. He has no idea.
Read the
what
U.S.
he's
Attorney's
talking
document.
about.
Okay, Storm, I think we've reached the end of round 3. I appreciate your time. And if anybody's worried, these people are running to be a prosecutor, like they handle this stuff in court all the time. So we're going to have closing statements, 90 seconds each. Mrs. Behenna, you are going to go first, followed by Mr. Calvey. 90 seconds to you to close out.
Thank you. And again, thank you for hosting this debate for us. I was born in Oklahoma County, and I've lived here most of my life. I care about this place. I care about public safety. I care about the criminal legal system. I care about people who are hurt and traumatized by violence. I've spent my entire career in the criminal legal system, and I would not have the reputation I have if I wasn't a person with integrity and fairness. I was a prosecutor here for 25 years, a defense lawyer, the director of the Oklahoma Innocence Project to help right wrongful convictions. My husband was career law enforcement. My opponent, on the other hand, is a career politician and lobbyist, and the only one up here on this stage that's been under investigation by the OSBI. If I take him at his word that he tried all of these cases while he was in the military for 1 year, which happened 14 years ago, with no other criminal trials since that time, he is still a rookie ADA. My opponent has never reviewed investigative files. He's never talked to investigators. He's never talked to witnesses. He's never had to sit with victims. He's never made charging decisions. He has never made the weighty sentencing decisions that a prosecutor has to make. I have done that for 25 years. I have not only made those decisions, but I have tried numerous cases. I have moved through the criminal legal system not to pad my resume for political gain, but because my heart moved me to these new challenges to try to make things better. My name is Vicki Behenna. I respectfully ask for your vote for District Attorney on November 8th.
Thank you very much. Mr. Calvey, we'll give you an extra 15 seconds or so, but up to 2 minutes for your closing, which went a little over.
Very good. My integrity speaks for itself, and as far as my record prosecuting, I would refer you to the Bronze Star Medal citation that the Army awarded me. They certainly would not have awarded that to me if I did not have integrity, and that describes in some detail the prosecutions I did over there. I have represented victims on VPOs and other things, and I do know that that's very important. I'm running for DA to put the focus of the office on public safety and helping victims of crime. My opponent said she's for fairness. I agree with fairness, but the focus has to be public safety. That is number one. Again, we can't afford to let Oklahoma County go the way of other urban areas led by Democrat DAs. I do have a lot of Democrat support. They know I'm going to change the DA's office, make it more fair to all the stakeholders in the system, including law enforcement, defense counsel, judges, everybody else. I did prosecute terrorists for the Army in a combat zone, and I'm sorry that she disparages the experience of veterans in saying I don't have experience doing prosecutions. Again, the DA in an urban county is an administrator who rarely prosecutes a case personally. You need somebody who is going to hit the ground running, working with all the stakeholders in the system. That's something I already am plugged into, and she is not. And most importantly, you need somebody as DA who is going to be able to go and make changes at the legislature to fully fund the DAs and all that, so we don't have any incentive to prosecute for profit and seek changes in the system that are going to policies that will lead that. As a Democrat, she won't get the first base out there. I will. I know how to do that. For the administration that this job is, and it's an administrative job, I am far more qualified than my opponent. And even if she does manage to get elected, I don't think it'll last long. Thank you.
Thank you very much. That, as I get to the end of it, that concludes our debate tonight. Thank you to the candidates for participating in this. It's not an easy task. I appreciate you both for doing this. It means a lot. You lead the way for other candidates. Thank you to News 9. Thank you to the Oklahoman, the Frontier, all our friends in the media who have shared and covered this debate. Remember, Election Day is November 8th. We have a gubernatorial debate between Kevin Stitt and Joy Hoffmeister on October 19th. Thank you all and good night. Hit that music, Parker.
Thank you so much. Thank you.